Hi, everyone. Welcome to this session's quarterly webinar with our Women's Health Working Group called Key Women's Health Market Updates. We're so happy to have you today. My name is Kayla Marty. I am a partner here at McGuireWoods in our healthcare group, and many of you look like very familiar faces, and I know that we have many people who often view this webinar not live as well. So for those of you rewatching, thank you so much for joining us. For everybody on the line, I'll give you a little bit of an update about the webinar, what we're going to cover, and then also some events that we would love to have your participation in if you have an interest. So for those of you who don't know a lot about McGuireWoods, we're a very large law firm in offices all across the country, and one of our significant practice groups is our healthcare and private equity group. So a lot of the updates here today will talk both from a healthcare operating company perspective, but also from a healthcare investor perspective on different issues that you may be interested in. So if you don't know a lot about our group, we're 50-plus attorneys that focus 100% of our time on healthcare issues. One of the areas that we spend a lot of time working in is the overall women's health space, so whether it be OBGYN, fertility, menopause care, and other women's-specific care areas. We spend a lot of time both on the facility side as well as on the provider side. So we're going to touch on a lot of different components, all from some of the latest updates that would apply across the industry, not just in women's health. We're going to talk a little bit about some very specific cases as well as ballot measures that have come out impacting women's health in the last several months. And then we're going to talk about several technology updates at the end of the session that we hope you all will find enjoyable and informative. This, like I said, is part of our quarterly webinar series with our Women's Health Working Group. If you like what you hear today and you'd like to participate in more webinars, please let us know. We'd love to have you anytime. We have also webinars that come out from our Regulatory Working Group and Hospital Working Group and several others that may be applicable to others on the phone. So don't hesitate to reach out to us. Our contact information will be on the slides that will be available if you have an interest in participating in any of those events. And those are all virtual events. We also have a couple of live events every year that we wanted to let you all know about before we get started. One is our healthcare private equity event in May. If you are either a healthcare operating company that has an interest in private equity or other investors, or is currently has healthcare private equity or other investors, this is a great event for you. It's in Chicago in May. If you have any interest, please reach out. We'd love to have you. We'd love to have your participation in panels, your participation in different events that we're doing. So we're happy to share the information about that. This year, we're also having a second session of what we call operating company boot camps. So it will be a half-day session to go over really key areas and updates just for operating companies. So whether you're a facility, whether you're a portfolio company, that's going to be a session that's very on topic for you and should be of a lot of interest, and that'll be on the first day before the event in Chicago. So if that's of interest and you'd like to participate, please let us know. There is also a healthcare private equity event coming to your city in all likelihood. We have a series of healthcare private equity pop-up events all across the country that are designed for networking and sharing market updates similar to what we're doing here that we would love to have you anytime. The ones that are slated for the first of next year, there's one today in Atlanta, so if you happen to be in Atlanta and want to participate, please let me know. But the ones that you're likely going to want to be participating in, we have one in January that's going to be in Denver, one in February that's going to be in Nashville, and then we have several in New York, Chicago, and Dallas planned as well. So please reach out if those are of interest, and we'd love to have you. So onto the actual content of our discussion, we are going to be providing bite-sized updates throughout this webinar that should be of interest to you about individual discrete topics that impact your businesses. There is absolutely no relationship between each of these topics other than women's health, and if you have specific questions about any of them, please always reach out. There is also a Q&A box on everyone's platform. If you have a question, please include it in the Q&A box. We will try to answer it during the presentation. If we're unable to answer it, we will reach out to you after the presentation to try to close the loop. Many people are unable to join, obviously, during the live session because everybody is very busy. This will be recorded and the slides will be available on our website about a week after the presentation. And so if anybody in your organization would benefit from this, any friends, colleagues, please feel free to pass it along. You'll get a link from us that has the information. So with that, we'll go ahead and get started with our presenters. So like I said, my name is Kayla Marty. I'm a partner in our group. Each of the people on your screen will be introducing themselves as they start their first topic area. But if any of these topics are of interest, you can reach out directly to these individuals. Okay, so the first area that we're going to talk about today is on the Corporate Transparency Act. You may or may not have heard of this in your organization. What we have noticed is this is an area that is getting underreported across operating companies, healthcare private equity companies in the country. And so even though this is not specific to only women's health providers, we wanted to make sure we're covering it today because it does have some upcoming deadlines, and it is something that many people were not aware was happening or they needed to take action on. So first of all, what is the Corporate Transparency Act? This is something that was actually enacted back in 2021, and the goal was really to avoid money laundering, tax fraud, and other activities that could result from entities operating within the United States. So when it goes into effect is for penalties is January 2024. What it requires is if you are an entity, you have to look to see if you need to be reporting on any of your beneficial owners with FinCEN. So this is the same organization that regulates other financial services companies like private equity funds, like hedge funds, things like that. Right now, you're going to be looking at whether or not you have to do that reporting or whether or not you meet one of the individual exceptions that falls under the Act. So let's say you don't meet an exception and you do have to report. The most common question is, what do we have to report? And so you're going to be looking at whether or not you have to report anyone that exercises substantial control over any of your organizations and anyone that owns 25% or more. And so you're going to be wanting to take a look and see for each of your individual entities in your organization, do they meet an exception or do they have to register? This is just a slide that you could use for reference in looking at what is implicated, what is the name of everything, what does it mean when you go back into your organizations. But it's critically important that you take a look at this and make sure that you meet an exception, or if you don't meet an exception, you are doing the reporting. So the next question we get are, what are the reports, how do I make them, and what are the deadlines? So this slide gives you some reference for what the individual deadlines are going to be for this type of reporting. So you did generally fall into one of two categories if you have to make a report, meaning you don't meet one of the exceptions. You're either an existing company or a new company. So if you're an existing company, it's exactly what it sounds like, that you were formed and existed prior to January 1, 2024. And so if you are one of those companies that exists today and you existed before January 1, 2024, you need to be reporting on your organization by January 1, 2025. So that's the deadline for existing companies. And then the other category is new reporting companies. So this means you were registered or created prior to January 1, 2024. If that was the case, then you need to be in a position where you are registering within 90 days of creation. And so we're still in that 90-day period at this point prior to January 1 of 2025. But when January 1, 2025 comes, if you are a new company at that point, you only have 30 days to register. So the period will be shortening a little bit, and that's something that you just need to be aware of. There's a little bit of information about the reports on this slide as well for your reference later, but this is something that's going to be really important for you to be aware of and be tracking. The next item relates mostly to you on the phone who are regularly doing different types of healthcare transactions. It is a very common misconception that healthcare transaction laws and state requirements related to healthcare transactions are limited to hospitals. That's not true. Or limited to, in some states, only HSR or very large transactions. The reason we included this topic area in the women's health presentation, even though it is applicable broadly across the industry and healthcare as a whole, is because it is very common that smaller operating companies are being triggered and caught under some of these state reporting laws. This graphic is a little bit of an older graphic we used on one of our articles about this same topic, so it just gives you a flavor of what the country looks like right now. It's changing every day, but there are some transactions such as joint ventures, reorganizations, significant strategic affiliations that are triggering state laws either intentionally or unintentionally for purposes of reporting transactions. So the purpose of these different laws was really a couple of fold. Number one, some laws were created so that state attorney generals could get greater notice and greater transparency about the large transactions that were happening in their state. That's one category. Another category of the type of laws are transactions that were aimed at trying to reduce transactions or provide more oversight over transactions that had the potential to increase cost or decrease access. And so these transaction laws tend to be a hybrid of what we think as healthcare antitrust laws and healthcare regulatory or licensing laws. And all of the states are very different. Some of them are based on a model law, so we see similarities. But if you are doing a transaction that's material in any way, even if it's not an M&A or acquisition transaction, and you are operating in a state that has one of these laws, we just wanted to flag this as something to be thinking about in the women's health area, because there is a fair amount of transactions going on constantly with hospitals, other individuals in the space from an operating company perspective, as well as with different healthcare investors. And if these laws aren't being paid attention to, there could be scenarios in which there's issues from a reviewability perspective. And in many cases, the Attorney General does have the power to come in and take issue with the transaction or investigate the transaction if it wasn't properly reported. And so this is just a flavor of what is happening across the country. But if you have specific questions about any of these laws, please do feel free to reach out to us. We work in them every day. We've filed something in almost all of the laws that are listed, so we're happy to talk about them on a case-by-case basis as well. The next thing we're going to talk about, I'm going to hand it over to my colleague Micaela to introduce herself and then also talk about some new non-discrimination laws that were put into place so that everybody has a good awareness of this area. This is something that impacts the women's health space, but also impacts a lot of other providers such as hospitals, other facilities, and physician groups. Micaela, can I turn it over to you?
Thanks, Kayla. Hi, everyone. My name is Micaela Enger. I am an associate in the healthcare department at McGuireWoods, and I sit in our Chicago office. So like Kayla mentioned, I'm going to talk a little bit about these new non-discrimination rules. And like Kayla said, these do apply to the women's health space, but also much broader. So earlier this year, in May, the U.S. Department of Health and Human Services Office for Civil Rights, or the OCR, and CMS published their final rule on non-discrimination under Section 1557 of the Affordable Care Act. Now, the 2024 rule was a significant departure from the 2020 rule and applies to nearly every healthcare provider. The rule applies to a greater number of programs and services, including recipients of Medicare Part B funds, health insurance insurers that receive federal financial assistance across their offerings, and the state and federal health insurance marketplaces. And it subjects patient care decision support tools and telehealth to the requirements of non-discrimination, as well as requiring that non-discrimination on the basis of sex includes sexual orientation and gender identity, which was consistent with the Supreme Court's holding in Bostock versus Clayton County. However, starting in May 2024, so almost right away after the rule was published, with the state of Florida and the Catholic Medical Association suing HHS, seeking to enjoin the rule based on it being arbitrary and capricious and conflicting with Florida law. So certain provisions of the final rule are stayed or enjoined. The court in Florida versus Department of Health and Human Services held that OCR may not enforce the interpretation of discrimination on the basis of sex. In Tennessee versus Becerra, the court stayed nationwide several regulations to the extent they extend discrimination on the basis of sex to include discrimination on the basis of gender identity, and enjoined HHS from enforcing the 2024 final rule to the extent that the final rule provides that sex discrimination encompasses gender identity. And notices of appeal have been filed in all three cases. So to back up a little bit, Section 1557 of the ACA prohibits discrimination on the basis of race, color, national origin, sex, age or disability, and healthcare programs or activities that receive federal funding, and this includes Medicare and Medicaid. While the rule is already in effect, covered entities have between 120 and 365 days from the effective date to comply with certain provisions. So as you'll see here on the slide, certain requirements come into play at different times. By July 5th, 2024, so earlier this year, covered entities must have ensured meaningful access for individuals with limited English proficiency and effective communication and accessibility for individuals with disabilities. And HHS does provide examples of such policies on their website. And the link can be found in some of our McGuireWoods resources to these examples. By November 2nd, 2024, so just a couple weeks ago, covered entities should have appointed a Section 1557 coordinator and provided patients with a notice of non-discrimination. A Section 1557 coordinator is really just an employee responsible for ensuring that a provider complies with all of the 1557 requirements. And then by May 1st, 2025, covered entities must identify and mitigate discrimination in the use of patient care decision support tools. By July 5th, 2025, covered entities must adopt non-discrimination policies and procedures and provide patients a notice of availability of language assistance services as well as auxiliary aids and services, and implement training. And notice of availability of language assistance services and auxiliary aids and services must be in English and in 15 languages most commonly spoken by individuals with limited English proficiency of the relevant state or state in which the covered entity operates. Next, I'm going to talk a little bit about non-competes. I know this has been relevant so much in the news this year and comes up a lot in these types of webinars. So we just wanted to touch on it because, again, it touches women's health, but again, is a much broader issue as well. So to provide a little background, in July 2021, President Biden issued an executive order encouraging the FTC to ban or limit non-compete agreements. And then between 2021 and 2022, the FTC published several policy statements casting a negative light more generally on non-compete. And in early January 2023, the FTC took legal action against 3 companies and 2 individuals over non-compete restrictions on thousands of workers. And this was really the first time the FTC enforced unlawful non-compete restrictions. Soon after, though, also in January 2023, the FTC proposed a rule to ban non-compete clauses, and the final rule was then issued in April 2024. The final rule provided it is an unfair method of competition, or i.e. a violation of the FTC Act, for a person to enter into a non-compete clause or to enforce most existing non-competes with a worker, including any senior executive. Now, the term worker includes all current and former employees, independent contractors, externs, interns, volunteers, apprentices, or sole proprietors. There were a few exceptions to the final rule for the bona fide sale of a business, or a cause of action related to a non-compete clause before the effective date, and for existing non-competes with senior executives. In terms of healthcare, commenters overwhelmingly stated that non-competes decrease patients' access to physicians of their choice, increase healthcare shortages, and negatively affect the quality of healthcare. And many felt that non-competes negatively affected physicians' ability to provide quality care, including emergency care. However, as many of us know, there were several legal challenges that followed. Most notably, in Ryan LLC versus FTC, a case out of the Northern District of Texas, the court issued a nationwide injunction on August 20th, 2024. The court found that the FTC lacks legal authority to adopt rules banning unfair methods of competition and that the FTC violated rulemaking limits. The FTC filed the notice of appeal on October 18th, earlier this year, last month. So as of now, the non-compete ban is stayed. The challenges in other states could lead to a circuit split, which would result in an eventual opinion from the United States Supreme Court to decide whether the FTC has authority to ban non-compete agreements. Additionally, also last month on October 7th, the National Labor Relations Board stated that the NLRB may take enforcement actions against employers with unlawful non-competes or stay or pay contract provisions. Section 7 of the National Labor Relations Act guarantees employees the right to self-organization, to form, join, or assist labor organizations, to bargain collectively through representatives of their own choosing, and to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection. And then Section 8 prohibits an employer from interfering with, restraining, or coercing employees in the exercise of the rights guaranteed by Section 7. Additionally, there has been a lot of state activity related to non-competes. For example, Illinois bans non-competes for employees who make less than $75,000 annually and non-solicits for employees that make less than $45,000 annually. And then Illinois also bans non-competes in certain sectors, including for certain healthcare professionals. Tennessee only allows covenants restricting healthcare providers if the duration is 2 years or less, and the geographic restriction does not exceed the greater of a 10-mile radius of the site of the healthcare provider or the county in which the healthcare provider's practice is located. California, North Dakota, Oklahoma, and Minnesota ban non-competes in most instances, sometimes with narrow exceptions for contracts tied to the sale of a business. And then New Hampshire, Colorado, Washington, Oregon, and Washington, D.C. restrict non-competes based on an annual worker salary with thresholds ranging from $30,000 to $150,000. And then some states like Delaware has a non-compete ban specific for physicians. McGuireWoods has published a lot of information around non-competes. So if you are interested in more information, we have an FAQ essential guide for navigating the ban, and then a follow-up article related to the Texas Federal District Court's decision.
Thanks, Micaela. And before we jump to the next section, though, I just wanted to flag that we do have a question that came in asking how Trump's election might impact the FTC appeal. From our perspective, nothing is assured, of course. There's many people that have publicly, within the Trump administration, supported the FTC's views, namely Vice President J.D. Vance, or future Vice President J.D. Vance. And so it is very uncertain at this point how things will proceed, whether they will be consistent with the Biden administration or whether or not they will be different. So stand by at this point but for people that believe that it'll be a radical shift, it may not be. So we're advising our contacts and clients not to count on that. Okay. Natalie, I think we're handing it over to you.
Yes, that's perfect. Hi, everyone. My name is Natalie Galdos. I'm in the healthcare group at McGuireWoods as well, and I sit in the Charlotte office. I'm going to be discussing medication abortion and some of the recent ballot measures that were part of November's election. As many of you, I'm sure, are aware, the Dobbs versus Jackson Women's Health Organization Supreme Court case had a major shift in abortion law throughout the United States. The Dobbs case centered on a 2018 Mississippi law which prevented most abortions after 15 weeks, which was much earlier than the viability threshold in Roe v. Wade and Planned Parenthood. In a 6-3 Supreme Court held that the Mississippi 15-week ban, as well as more significantly, the 5-4 majority ruled to overturn Roe v. Wade, stating that the Constitution does not confer a right to abortion. This decision effectively shifted authority over to the individual states and increased the concept of trigger laws in various states that would either restrict or outright ban abortions, including bans on medication abortion. Medication abortion, unlike surgical procedures, is a non-invasive way and includes the use of mifepristone, which accounts for over half of the abortions in the United States. The FDA approved mifepristone in 2000, but over the years, its accessibility and availability have evolved significantly, particularly during the rise of the COVID pandemic due to telehealth services. During the pandemic, the FDA lifted the in-person requirement and permitted telehealth consultations, which allowed patients to receive medication by mail without needing to visit a clinic. After Dobbs, many states enacted new restrictions on medication abortion use. These include either telemedicine consultations needed to be in person or full-out bans on this medicine. At a federal level, the DOJ and the DEA had supported the FDA's approval of mifepristone. However, the state versus federal tension reached a critical point in the FDA versus Alliance Hippocratic Medicine, where a group that said that without having the proper background in terms of patient safety, that the FDA would not be able to allow telehealth prescriptions of medication abortion. In August 2023, the Fifth Circuit ruled to uphold the FDA's use of medication abortion, but impose certain restrictions such as reversing expanded telehealth access. When these restrictions become fully enforced, patients are kind of forced to go in person and no longer use the telehealth services. This case went up to the Supreme Court. However, the justices decided not to address the substantive issues in place and focus on the procedural issue regarding the lack of standing. By the Supreme Court avoiding ruling on these two major issues, some of the ongoing discussions that are subject to future legal ruling we expect includes whether the FDA has authority over mifepristone's use should supersede state laws, as well as the Comstock Act and whether it will apply to specific abortion medications going forward. Even outside the courts, there's still various state-level actions involved that continue to shape this issue. For example, Texas legislators have issued warnings to various corporations of providing out-of-state abortion-related travel benefits, arguing that reimbursement for such services could violate Texas law. We expect there's going to be further discussion between the courts and Congress on this issue, and so we wanted to just flag to be aware of some of these issues in various states. Next is on the abortion ballot measures. Since the Supreme Court's ruling in Dobbs, voters in 16 states have weighed in on constitutional amendments regarding abortion, and as recently as November, we had 10 states consider abortion-related ballot measures. Overall, 7 states ruled in favor of increasing abortion access, and 3 states were not able to pass constitutional amendments. A couple that we wanted to highlight included Arizona, which passed Proposition 139, which established a state constitutional right to abortion up to fetal viability, as well as exceptions for the health of a pregnant individual. And the new constitutional right also discussed preventing penalizing providers for assisting in abortion, as well as in Nebraska. Nebraska brought 2 conflicting measures on the ballot. One of the initiatives would include the state constitutional right to abortion until viability, or later to protect the health of a pregnant woman. The other was involving a right into the Constitution for the current 12-week ban, with few exceptions for rape, incest, or saving the life of the mother. The 12-week ban was approved to 45%. However, the other abortion until viability measure was rejected. And lastly, another hot state that was contested was in Nevada. The state approved a constitutional amendment to establish a right to reproductive freedom, including decisions on prenatal care, childbirth, postpartum care, birth control, miscarriages, and abortion care. As you can see, a lot of states are now having these measures come to ballot, and this kind of highlights the nationwide focus on reproductive rights. Next, I'm going to switch it over to Kayla to discuss the mail-in drug orders.
Thanks, Natalie. Thanks, everyone. This is another area that affects physician practices specifically. So if you're a OB practice in particular, certain fertility practices, menopause care, and other providers of women's health, this is something that's going to be particularly important to you. This is an item that applies to women's health providers, but also applies more broadly across the board. It's something that has gotten some attention from a legal perspective, but has not gotten a lot of attention within different trade organizations and things like that. So we just wanted to highlight this as an area that CMS has been focused on, to the extent that you all in your organizations have a significant amount of federal funding. So this all started in September of 2021 when CMS issued an FAQ stating that CMS did not believe drugs provided by mail would qualify for the Stark Law exception under the in-office ancillary services exception. If you all are affiliated with a hospital or physician practice, you're probably very aware of the in-office ancillary services exception. The reason that CMS took this position was that they did not believe that drugs by mail could satisfy the requirements for actually the same location and other location tests within the in-office ancillary services exception, for those of you who have a lot of experience in that area. Trade organizations, law firms, providers, many people disagreed with CMS's position and actually initiated a lawsuit against that position in the U.S. District Court for D.C. In that lawsuit, CMS's position was affirmed in August of 2024. There continues to be significant controversy over this particular FAQ and the position of whether or not mail-order drugs can be considered for the in-office ancillary services exception. So this is just something we want you all to be aware is being talked about. There have been bills introduced directly in Congress supporting the position of the trade organization and providers that were challenging this FAQ. So this may continue to evolve. We wanted to flag it so you would be in a position to be able to track it for your own organizations. Separate and apart from the CMS FAQ that's generated some attention, one thing that we also wanted to flag with respect to any kind of drug delivery within the in-office setting is being very aware of the state fraud and abuse laws and the state pharmacy laws. even if legislation is passed at the federal level or positions changed by CMS at the federal level, states across the country have very different positions on any kind of drug dispensing within physicians' offices and whether or not you have to have certain types of licenses, and as well as like the type of provider that is eligible to dispense, what type of packaging, labeling, and provision has to be given to patients. So, for example, Maryland has very detailed laws on this topic. We've been very down in the weeds on those. California also has detailed laws on this topic, and they differ sometimes from the federal position. So this is something we just wanted to flag for continued tracking because, like I said, it has gotten some attention as of late. Natalie, back to you for IVF.
Yes, thanks, Kayla. In this section, we're going to talk about the recent legal developments surrounding IVF. This is an area in women's health that's rapidly evolving with significant legal implications for patients, providers, and policymakers. First, we wanted to flag that there continues to be differences in the various states on how they approach IVF coverage. There are some states like Massachusetts and New Jersey that mandate insurance coverage for IVF treatment. However, most states coverage for IVF is left to the discretion of the individual insurers. It's likely that some of the lack of uniform coverage throughout IVF treatment will lead to future litigation issues. One of the big landmark cases in IVF involves the Alabama Supreme Court in the LePage case. This case involved the legal status of embryos in the state. On February 16th, 2024, the Alabama Supreme Court ruled that stored embryos must be given the same legal protections as children under Alabama's Wrongful Death of a Minor Act of 1872. As a result, the court then held that the wrongful destruction of embryos could legally constitute a wrongful death, allowing parents to pursue wrongful death claims if an embryo is harmed or destroyed negligently or maliciously. When this case came about, very quickly the Alabama legislature responded due to rising concerns on potential legal and liability issues for IVF clinics and fertility specialists. To address these concerns, on March 6, 2024, the Alabama legislature passed a law granting criminal and civil immunity for IVF providers, which would effectively shield them from liability under the Wrongful Death of a Minor Act in the case of handling embryos. The law was seen as a protective measure for IVF practitioners and had bipartisan support, allowing practitioners to continue offering reproductive services without the risk of facing wrongful death claims related to handling of embryos. While this was a state-level decision, has an immediate impact in Alabama, it also highlights the broader issues surrounding IVF and reproductive technology laws across the United States, particularly on the status concerning the legal status of the embryos. Under federal law right now, there are no specific protections or statutory rights directly addressing IVF, which has resulted in various state laws creating decisions or policy on this subject. Various federal legislators have proposed measures aimed at protecting access to IVF services. One of the significant federal measures included the Right to IVF Act, which sought to establish a statutory right for individuals to access IVF services and protect IVF providers from subsequent legal action regarding embryo handling. This proposed act would have ensured that individuals seeking IVF treatment could do so without interference and have safeguards in place. However, the bill was ultimately blocked in the Senate, leaving for continued inconsistent federal versus state protection and guidelines for IVF. Next, I'm going to transition over to Micaela to discuss the access to contraception.
Thanks, Natalie. So access to contraception is controlled both at the federal and state level. So to provide a little bit of context, the Supreme Court established the right to contraception in two cases, in Griswold versus Connecticut in 1965 and Eisenstadt v. Baird in 1972. In Griswold, the court recognized that the constitutional right to privacy encompasses the right of married people to obtain contraceptives, and in Eisenstadt, it extended the right to unmarried people. So that's a little bit of background about the right to contraception. And then last month, in October, the Biden administration proposed new rules to expand coverage of affordable contraception under the Affordable Care Act. Some key parts of the proposed rules include access to over-the-counter contraceptives without cost sharing, expanding education efforts on over-the-counter contraception by requiring private health plans to disclose that over-the-counter contraception is covered without cost sharing or prescription. Also, that health plans will be required to cover every FDA-approved contraceptive drug or drug-led combination product without cost sharing, unless the plan also covers a therapeutic equivalent without cost sharing, to assist in eliminating barriers that some women face or continue to face in accessing contraception prescribed by their provider. These new rules were proposed after President Biden called on federal agencies to assure that access to contraceptive services and supplies is broad and unimpeded by barriers related to cost, coverage, and availability. At the federal level, the Affordable Care Act requires most plans to offer coverage of birth control with no out-of-pocket costs, but companies may opt out from offering contraceptives for religious reasons as established in Hobby Lobby v. Burwell. In 2022, the House of Representatives passed the Right to Contraceptive Act, which aimed to protect a person's ability to access contraception and to protect a healthcare provider's ability to provide contraception and information on contraception. But this measure was blocked in the Senate in 2024. Moreover, the House of Representatives introduced the Access to Safe Contraception Act of 2022. This act would preempt states from banning any form of FDA-approved contraception, but as of now, no vote has been held on this bill. Additionally, something to note is that the FDA approved the first over-the-counter birth control in 2023. This form of birth control began being sold earlier this year. Now, at the state level, many states have established the right to contraception. 10 states, for example, a few are Colorado, Florida, Illinois, Massachusetts, Minnesota, New Jersey, and also Washington, D.C., have passed legislation protecting access. And then in 4 states, voters have passed constitutional amendments through ballot measures. These constitutional protections recognize a broad right to reproductive autonomy, as discussed earlier. In California, Michigan, and Vermont, voters passed constitutional amendments through ballot measures in 2022, recognizing a broad right to reproductive autonomy, as I mentioned, which does include the right to use or refuse contraception. And in 2023, Ohio voters approved Prop 1, amending their state constitution to protect reproductive decisions, including those regarding contraception and abortion. The additional ballot measures that were previously discussed also do apply. While access to contraceptives remains broadly legal, there have been some efforts to limit access, especially for emergency contraceptives. This includes things like Plan B. In 2020, Texas received permission to exclude emergency contraceptives from its Medicaid-funded family planning program, and that waiver ends next month. And the Missouri Senate voted on a bill that would have barred coverage of emergency contraceptives in Medicaid. However, the measure failed, and it would be an open question of law if Missouri had the authority to restrict access without federal authorization. So now I'm going to hand it over to Jen.
Thanks, Micaela. Hi, everyone. I'm Jen Shanley. I'm a partner in McGuireWoods' healthcare group. I'm based out of the New York office, and I will be giving you some bite-sized nuggets and updates on HIPAA. So we wanted to highlight to you HIPAA and its applicability or inapplicability to the femtech industry. You may be aware, but there is a common misconception in the public and among consumers that HIPAA applies to all health information in all contexts. You might have seen comments on Facebook from people saying that's a HIPAA violation and the like. And while HIPAA is a helpful tool to protect health information, its scope is narrower than many people realize. Just because there's identifiable health information involved doesn't mean HIPAA and its protections apply. HIPAA has a very defined scope. It actually only applies to covered entities and their business associates. And covered entities are a defined term. It's health plans, healthcare clearinghouses, which are basically intermediaries that process claims, and healthcare providers that engage in standard electronic transactions, which is essentially interacting with insurance plans in an electronic means. So not even all healthcare providers are actually subject to HIPAA. And then another category of entities that are subject are business associates. Those are entities that perform functions and activities on a covered entity's behalf that involves access to individually identifiable information. So if an entity is not a covered entity or a business associate as defined by HIPAA, HIPAA does not apply to them. Other laws likely do, but not HIPAA. We raise this because it's critical to keep in mind that if you're operating in the femtech industry, you need to do an analysis to determine if HIPAA applies, and if not, what does. As many of these apps and tech providers in this women's health industry are actually not covered by HIPAA. So highlight the need for a fact-based analysis that McGuireWoods can assist with if you need assistance there. So just something to kind of put in a real-life example, you can have an app that tracks, say, menstruation levels. And if it's provided directly to a consumer, Jen Shanley is downloading it on my own, I'm paying for it on my own, it's solely between me and the app provider. In that scenario, HIPAA would not apply. The app provider is not providing something for on behalf of a covered entity, either as itself, because there's no insurance, or as a business associate. However, that same app with the same information being collected and the like, if it is provided to me, Jen Shanley, through my doctor that collects insurance electronically, that app is now covered by HIPAA. Similarly, if it was provided through a health plan or another covered entity or entity subject to HIPAA. So we raise this because this is obviously something critical to the operations of these types of entities, but also to note that this is something that needs to be continually monitored. Many clients of ours start maybe as a direct-to-consumer market strategy, but then they expand operations, they have success, and now health systems, hospitals, health insurance plans want to provide their services to their patients or their members. Well, that change would have an implication on whether HIPAA applies and what is necessary for compliance. So we raise that to say a few things. One, have your growth plans in mind when you're developing this. When determining your material vendors, are they in a position to comply in the future if you need them to? We've seen clients who have rolled it out, understanding that the current landscape HIPAA does not apply to their current operations, but then they're limited with their expansion plans because material providers or vendors of theirs are not positioned or willing to become subject to or compliant with HIPAA. So just raise that as something to keep in mind and continually monitoring. The other reason was that I wanted to provide that background to set the stage for the next topic. There's been a lot of discussions regarding femtech apps and privacy considerations, a lot of news articles and the like, particularly after the Dobbs decision. A lot of industry stakeholders were wondering what this means for them regarding their disclosure obligations. What if they receive a request for information? What do they need to do? What can't they do? And this may seem obvious, but their obligations are going to depend on what law applies and what the law says. For those entities subject to HIPAA, HIPAA will determine their obligations, or in some scenarios, a more restrictive law if it also applies. But a lot of entities that were subject to HIPAA were also unclear with what their obligations were. And the federal government had issued first guidance and then followed by regulation, giving some clarity there. One thing to note is there was a lot of interest in the industry on this. The final rule commentary actually noted that OCR, that the agency that was issuing the regulation and the guidance, that they received almost 30,000 comments to their proposed rule on this. And essentially the final rule, and it's consistent with the guidance, said that entities subject to HIPAA must not release PHI if the purpose of the request is to investigate or impose liability on an individual for obtaining or providing reproductive care that was lawful under the circumstances in which the care was provided. It also requires the entity, before disclosing, to obtain an attestation from the requester that the information was not going to be used for that purpose. In covered entities that are required to have notice of privacy practices under HIPAA were required to update their notice of privacy practices to support reproductive privacy, is how they put it. One large caveat with this update is this guidance, this regulation, it's for entities subject to HIPAA. For those that are not subject to HIPAA, other laws, would, typically state laws, would apply and govern. We flagged this to note it's an evolving issue. There's evolving landscapes with updates here. We don't know the impact that the incoming and presidential administration will have on this. We're monitoring it. Unclear whether the guidance and the final rule will be rescinded, whether be left to the states. We are still following this. We're also watching with Chevron consequent or updates to see if there is any impact of that on the regulatory, the deference to regulatory guidance and regulations and the like there. So what does this mean? Really wanted to flag this to say, first, if you receive a request and you're unclear on the obligations, to contact counsel for assistance in determining what law applies, and then under that law, what's their disclosure obligations to protect the interests of your organization. The other point to note, too, is to be mindful of the statements that your organization's making to consumers. If not, particularly even if you're not subject to HIPAA, there's privacy policies, marketing materials, and the like that are likely holding out to the consumers how you will use their information and how you will disclose it. Things we want to flag for if you have statements, and we will never share your information with third parties, or under no circumstances will this be shared. You may want to look at that and get guidance there to see if there's additional need for flexibility and room for some of these nuances that may not be as clear-cut. So raising those to just show that this is a complicated, nuanced area that McGuireWoods and our team here can help you navigate. And with that, I'm looking at the time and want to give a few people a few minutes if they're participating in their lunch break. But we conclude today's webinar. We want to thank you all for your participation, whether it is live or through a recorded session. We hope you can join us again in the future during any of our future webinars or events. And if you have any questions or comments, I don't see any additional ones in the chat, but if you have any questions or comments about any of the topics we discussed today or otherwise, please don't hesitate to reach out to the presenters today, including myself, and be happy to hear from you. Thank you, everybody.